Good morning. Thank you all for being here today. I think everyone here is here for the required training for new Board of Regents and Community College trustees. And this is on the Effective and Ethical Governance panel. So before I introduce our distinguished panelists, I wanted to give a little bit of background about what to expect at the panel today. This panel has a kind of a twofold purpose. One is, of course, to meet your statutory obligations to take this training, which as lawyers we know is very important. But the second one is really also to provide you with a framework for issue spotting and problem solving in real issues that you are going to face in your day-to-day service of your institutions and your community colleges and at the four-year universities. And it's really important not to learn everything today, you will not be able to memorize every statute, but really to get a sense of when you are approaching a decision point and may need to seek counsel or take a pause and think about what you're going to do next when faced with some of these dilemmas. So the good news for you is that you have an extremely accomplished and experienced panel of subject matter experts this morning. These three lawyers have more than 80 years of combined legal experience. They represent the full range of community college trustees, board of regents, and then also institution president. And so they can kind of give really a 360 view of some kind of the ethical obligations and problems that you may face at your institutions. These three practitioners also really have a depth of experience, having each been trial lawyers, appellate practitioners, and general counsel. So I'm going to tell you a little bit about their backgrounds, and then we're going to kind of engage in a Q&A for you all to hear the questions and kind of get their perspectives. So to my immediate right is Agustin Rivera. He's the general counsel for the Del Mar College District. He's also a member of the president's executive team there. He has joined Del Mar in 2015. He has more than 27 years of private practice, trial, and appellate experience. He is also on the board of law examiners. He is on the NACUA board as well. And he has been honored with the Judge Paul W. Nye Professionalism Award, which recognizes lawyers exemplifying the highest ethical standards. He is a graduate of Yale University and Stanford Law School. To his right is Amanda Cochran-McCall. She serves as the Deputy Vice President of Legal Affairs for University of Texas at Austin. She serves as in-house counsel, addressing a broad array of fascinating legal issues, which will include discussions about First Amendment and academic freedom that we're also going to touch on as a fun freebie for this panel today for you all. Before joining the university, Amanda served in various roles over more than a decade at the Office of the Attorney General, where I had the pleasure of working with Amanda. She is also a very experienced trial and appellate practitioner and has her degrees from the University of Texas at Austin and Oklahoma City University School of Law. Finally, on the end, we have Nellie Herrera, who's the general counsel of the Texas State University System. She's been with that office since July of 2011, and prior to that, she was also served as a division chief, as did Amanda, at the Office of Attorney General, engaging in extensive trial and appellate practice for the Office of Attorney General, representing a broad array of clients, including institutions of higher education. And she has her degree from the St. Mary's University and a JD from UT School of Law. So with that introduction, I am just going to launch into the questions for these very experienced and talented lawyers. So as an overview, we wanted to kind of create a framework for you of what your obligations are. So as a fiduciary, board members owe certain duties to their institutions, including care, obedience, and loyalty. And so I'm going to ask each one of them to give you a brief overview of what that is, so that going forward, when you try to make decisions for your institutions, you can consider, am I carrying out my obligation to exercise care, duty, or loyalty to my institution. So I'm going to start with Nellie. Nellie, do you want to give a kind of a brief overview of the duty of care?
Absolutely. And thank you very much for being here this morning. And before I talk about the duty of care, I just want to take a minute to congratulate you on your new positions as regent or trustee. You know, your position comes with a great deal of authority and a great deal of responsibility. So thank you very much for taking up that mantle. The work you will be doing will be transformational for your institutions. So, the duty of care. It is a simple, simple duty. And I can tell you this is how you can carry out that duty. The duty of care refers to your responsibility to act as a reasonably prudent person when it comes to exercising your decision making powers here. You are going to ensure that you are reasonably informed as a trustee or a regent. Remember, I said reasonably informed, not a subject matter expert. You are not expected to be a subject matter expert. The great thing about your positions is that you will have access to subject matter experts like your lawyers or your CFOs or your auditors. Those are the people who you will be able to rely on and depend on to help you in making your decisions, because your decisions will be at a policy making level. You are high level policy makers. You are not managers. You are not expected to engage in the day-to-day management of your institutions. And that is critical here. It is so important that you all remember no one has charged you or tasked you with the responsibility of trying to figure out the absolute day-to-day operations of your institution. Absolutely not. You are being charged and tasked with understanding that you are a high-level policy maker and that you are going to rely on others who are the subject matter experts to help you in making your decisions. So your duty of care is one of being reasonably informed. How do you go about being reasonably informed? Super simple. And when I say it, you're going to go, well, duh. Okay, go with me here. You become reasonably informed by attending board meetings, by attending all board meetings, by reading your board packet, by reading all of the material in your board packet before your board meeting. Now, why do you do that? Because you want to be able to attend the board meeting and be engaged. You want to be able to ask those questions of those subject matter experts so that they can explain to you why they are coming forward with certain propositions or certain proposals. So in this case, when you talk about your duty of care, remember this. It is your job to be reasonably informed. You become reasonably informed by relying on those subject matter experts that you have access to. And in a nutshell, I think that's it.
Thanks, Nellie. Amanda, do you want to handle the duty of loyalty?
Yes. Good morning. I also want to echo Nellie's sentiments and just congratulate each of you. It's an exciting time, I'm sure, taking on this important responsibility and getting the opportunity to really make a difference every day at your institutions. Um, the duty of loyalty is really about your responsibility to put the best interest of your institution first. Um, it also requires that you're loyal at all times. What does that really mean? That means you have an obligation to avoid conflicts of interest and even possible conflicts of interest. Um, it means when you learn about information in your role, you have a duty to keep it confidential. It's the board or the board's business. It's confidential and it's to be used for the purposes to further the board that you're on, not for personal gain. One of the easiest examples of things that could potentially breach this duty would be to use information that you learned in that context for your personal gain. Because by doing that, you wouldn't be acting in the best interest of the institution. Um, the other thing to think about is in the conflict of interest category. So conflicts of interest are very straightforward when they actually exist, but sometimes people forget that this duty also includes the obligation to avoid possible important to kind of think through what I call a reasonable person test for yourself when you're trying to figure out, is this an instance that could cause a conflict of interest or a potential conflict of interest or the appearance of a conflict of interest? And that's to ask yourself, if a reasonable person who's a stranger, who doesn't know about what's going on, but somehow learns about a relationship that you have or a business interest that you have, and then they hear about, as a board member, what you're getting to make a decision on, would they hear that and think, huh, I wonder if this person is acting in a way to benefit themselves, like they're getting something out of it for themselves? If you use that question as a tool, it'll help you identify instances where somebody who's a bystander would say, oh, that makes me question that. That's a good indication that it's a potential or has the appearance of a conflict of interest. And so I just offer that as something to help you kind of think through what kinds of things could be instances that cause the appearance of a conflict of interest. Um, the other thing that aspect includes is the duty to disclose that. So if you identify one of these conflicts of interest, the duty of loyalty requires you to alert the counsel for the board and the other board members um, of your conflict of interest or the potential conflict of interest, because that allows the group and the individuals in charge, whether that's a general counsel or the members, to vote on how that may impact what your role will be on the decision at that time in front of the board. Because at the end of the day, the goal is to ensure the integrity of what the board does as a group. And if a participant has a conflict, that can undermine the overall integrity of the decision making of that group. And so again, this is why the duty of loyalty includes that obligation to proactively disclose those kinds of concerns so that you're not just deciding to handle it on your own. That's kind of it, putting the interest of the entity above your own and maintaining that duty of loyalty at all times.
Thanks, Amanda. Augie, do you want to inform folks about the duty of obedience?
Sure, thank you. Good morning, everyone. Let me start off by asking, how many community college folks do we have here? All right, it's good to see you all. But I want to come in and concur with what Amanda and Nellie have said and give you my personal thanks. I know what you do. I know it's not easy, and you're here learning how to do it better. So thank you. Continue doing what you're doing, and never forget that all of us we're here to help. And I also want to thank Nicole for inviting us and putting this panel together, and everything that the coordinating board does to support us out there in the field. The duty of obedience has two components to it. Basically, you have to follow what your stated mission and your vision is for your institution. And second, you have to make sure that you're obeying the law. Now, the mission and vision of your institution, I'll leave that up to you. You should know what that is. If not, go back and look at it. I'm sure that you probably do that on a regular basis. I know we do at Del Mar College. But what you want to do is make sure that you're obeying the law and that you're conducting yourself and carrying out your duties lawfully. And that doesn't mean just following federal and state law, but it also means following your policies. Are you acting in accordance with your policies? Are you acting in accordance with your bylaws? Are you acting in accordance with the code of ethics that you all have agreed as a compact that you're going to follow? Now, it's important to periodically review and reevaluate whether you're doing that, whether you have a board self-evaluation that you conduct on an annual basis, or whether you have an annual ethics update like we do at Del Mar College, where we specifically take the time at a board meeting to pull out the bylaws and go over them again. However you do it, you need to make sure that you're doing that on a regular basis to make sure that at all times that not only the institution, but that you yourself as a regent or trustee is acting in accordance with the mission and purposes. Again, examples, practical tips, scheduled reviews of the mission and vision statement. Again, doing a regular update, looking at your college or university strategic plan and making sure that you're following that. Anchoring your agenda items to a specific section of your strategic plan. Sounds simple, but it actually goes a long way to making sure that every time that agenda is prepared, you're tying a specific agenda item to something specific in your governance documents. um, having scheduled visits and with your internal auditors. And finally, again, if I can brag a little bit, at Del Mar College, we started this over 10 years ago, where once a year they ask me as the counsel for the board to prepare and present an annual ethics update. It's on the board calendar. We do it in February, and we take time out in public session to review the bylaws and to make sure that everything's going straight. I also take the opportunity to talk about something topical that's ethical, and I'll talk a little bit more in the presentation about what they do after that. So that's the duty of obedience.
Thank you so much. And we are going to shift to, I think, one of the areas where the law is fairly prescriptive, and where if you as board members or trustees have any kind of outside business interest, you are likely to face ethical quandaries. And that's in the area of contracting. So we're going to, again, start back with Mr. Rivera talking about the Local Government Code 176. And so that describes the requirements for conflicts of interest disclosure for board members who contract with certain vendors. And can you give us just a brief overview of those obligations and how you counsel community college trustees in navigating those?
Sure. First of all, it sounds simple, but my first answer is always it's complicated, okay? Particularly for those of you that live in communities where invariably you're going to intersect with each other. You know, you're doing this public servant role, and yet you've got to make a living. You know, you're not getting paid for what you do as a regent, so you may have business relationships that sometimes just happen to intersect with what you do as a regent or trustee. So if you're not familiar with Rules 176, I would commend it to you. Pull it out and see when you do have to file a conflict of interest because of a particular transaction or deal or business relationship that you've entered into. There's a form that you have to fill it out, and you've got to do it pretty promptly. You've got to do it within 7 days of realizing that there is in fact a conflict. It's got to be filed with the administrator at the college responsible for that, and it's got to be posted on your website. As we like to point out, sometimes there are rules that you should follow because they're the right thing to do, and then there are rules that are kind of like jail rules, and these are kind of like jail rules. So these are very serious. And so if you have any questions, I mean, this goes throughout, and I'm sure Amanda, Nellie, and Nicole would agree with me. You ever have any questions, ask. There's no question that's too silly or that you should take for granted in this arena. I did want to point out also that this applies to gifts that you receive. Okay, especially if you're a new regent or trustee, all of a sudden you're everybody's friend and they want to give you this and they want to give you that. Well, there are very low monetary values for that, and you've got to be careful because unless it's coming from a friend that you've had for a very, very long time, you've got to be careful about whether you can accept a gift. Out of respect for the limited time that we have, I will say this. And give a plug for our friends over at TASB, the Texas Association of School Boards. Our dear friend Amy McGee over there does a great job in running the legal office there. And they've prepared a white paper that's available online. You don't have to be a TASB member. That's entitled Gifts to Public School Trustees and Employees. And there's a wonderful flow chart at the end that just walks you through about whether or not you should accept a gift. Now, the easiest answer is don't ever accept anything, right? But is that practical? Not always. I mean, it's probably the safest. You can sleep at night, but in case you ever have to do this, this walks you through it. That's a very general overview of 176, but happy to answer questions afterwards if you have anything specific.
Great. Yeah, and I think Augie raises a really important point, which is many of these prescriptions and statutes are penal code violations. And so when you receive counsel from your general counsel, we cannot change how a prosecutor sees the law. So when we counsel you, we're giving you the best advice. But if it is a prosecutable penal code offense, that is an area you want to be more careful in because we can't, protect you essentially from prosecution if a prosecutor sees something differently. And then the other issue is just to be mindful that it also can put your board at risk and the actions of the board and jeopardize procurements and contracts. So similarly, Nellie is going to help you all understand what 51.923 for board members that wish to contract or transact with a business in which one of the board members may have an ownership interest. And so Nellie will talk about whether that's strictly prohibited or if there's other actions or limitations that the board member can take protectively.
Sure. And, I love statutes. I love them because they tell you what to do. And I'm a real, okay, tell me what to do. Yes, I will do this. I'm all about the order of things. And statutes are going to help you do your jobs as trustees and regents. You know, it's telling, when they lay it out for you and say, this is what you must do, this is what you must do. In a situation where, first of all, a regent or a trustee has an interest in a business, and the institution it wants to contract with that business. At first blush, you might think, well, that's going to be prohibited. No, it's not. An institution of higher education may contract with a business in which a regent or a trustee has an interest. It's okay. The statute says it's okay. The statute even says it doesn't matter if your interest, the trustee's interest or the regent's interest, is substantial. Doesn't matter. And the reason is because the statute also says this is what you must do. You must absolutely state that in an open session. So at a board meeting, in an open session, not executive session, but in an open session, you must disclose your interest in that business. That's one. The next thing you do, you don't vote when it comes down to vote. When it comes down to a vote, you don't vote and you don't participate in the vote. Number three, if it's going to carry the day, the vote must be by majority of the regents and trustee. So that's it. It's pretty simple. If you do those things, you will have actually carried out part of your responsibility on duty of obedience that Augie talked about because you're following the law, and duty of loyalty that Amanda talked about because you are putting the interest of the institution here because you're laying it all out for everybody to see. So it's pretty simple. I like laws. I think you will too.
Thanks, Nellie. I'm going to skip down because I do want to, since we have some kind of more fun and interesting topics, but I think it's really important for these council to help you all think through how to identify when you have a conflict of interest. So I'm just going to ask each panelist, I'm going to start with Amanda, how do you help board members or trustees or your clients in general identify in the first instance when they may have a conflict of interest?
So I think the first step is all of you having assumed these new positions. I think it's important before we're ever at a point where there is a conflict or a potential conflict to put some time into thinking about, okay, what are my various business interests? What are my social connections that might come to play or somehow be related to something that comes before the board? And then there's also just personal interests, and only you might know what those are, plans you have for the future, that sort of thing. And I think it's a good idea to kind of have an idea of those things just as a general working matter, and then to have the diligence when you're exercising your duty of care to read those packets about what's coming before you at that time, to just be aware and be doing that through the lens of what are my own personal interests or business interests or social interests, because that's going to sort of cause that little red flag to come up and indicate to you here's a potential conflict issue. And so if you're exercising a diligence in terms of kind of having that in the back of your mind as a general awareness, those kinds of things are going to pop up for you. And then when in doubt, always reach out to get counsel and say, hey, these are the things going on. Here's my interest. Here's what I'm concerned about. Is there a conflict issue here? You don't have to figure it out on yourself by yourself. And certainly there are instances where there are statutes that clearly tell you what to do once that you identify a certain kind of conflict. But the real kind of murky thing is sometimes it's not clear, based on whatever the facts presented are, whether or not something is an actual conflict or it appears to be a conflict that requires some sort of step. And so it's always the safest bet, when in doubt, to ask for advice from legal counsel on that.
Augie, do you want to weigh in on that one?
Absolutely.
Okay.
So the identification of conflicts, it's not like a Supreme Court justice said one time, I'll know it when I see it. I mean, it can get tricky. And so I've always been a big proponent of, preparing, building the ark before the rain, right? And so when we get a new region and trusting, I've got to give a shout out. We've got our board liaison, Ms. Delia Pettis here from Del Mar College, and she does a great job. Over the years, recently, frankly, we have developed an intensive onboarding process where when a new trustee or regent comes on, they spend time. I mean, it's literally over a matter of weeks, and Ms. Pettis schedules time with the president, with the general counsel, and one of the things we specifically cover, at least in my review, are conflicts. And we want to tell them you're going to have to think about this all the time. This is going to be part of what you do. And so you need to start familiarizing yourself with what the rules are and when you have to report something and when you have to recuse yourself and step back from something. So that's how we began preparing, for the identification of conflicts. The other thing, the other shout out I want to give is to one of our regents, Libby Averett. Regent Averett, who's sitting up there, actually led the college through a very intensive review of our board bylaws a couple of years ago and produced a report in 6 months that was an upgraded version. It was a lot of time and effort that went into it. And the ad hoc committee spent a lot of time really looking at the code of ethics. And they came up with, so what happens after the annual ethics update in February is every board member personally signs a commitment that they've gone through the training and then that they're committing to conduct themselves in an ethical manner throughout the year until the next ethics training. And that's filed with us, and we keep it, and it's on the website. And it's a demonstrative commitment, right, to ethics. It may sound simple, you're just signing something, but I think to each and every one of my regents, at least, this means something to them. This is a public demonstration of what they're going to do. The other thing that they came up with out of the ad hoc committee is, well, you're not required to file personal financial statements. Exactly what Amanda was talking about. Every year they're going to file. Every regent will file a personal disclosure statement is what we call it. Now, it's not as lengthy as many that you've seen, but they have to identify associations or groups that they belong to. They have to identify business relationships that they have. It's only a 3-question document, but it forces them at that point in time to identify, who they are and how their what their interactions and relationships are at that point in time. Again, to prepare them for when the rain does come.
Just real briefly, I'm just going to echo what Amanda said, and Augie too. If you aren't sure, call your lawyer. Please call us. So many people I've heard, they say, oh, we didn't want to bother you because we know you're busy. No, we're busy. We want to be busy. We are there for you. So don't ever hesitate to pick up the phone and call the lawyer. The lawyer is never too busy to take a call from a regent or a trustee who is struggling on deciding whether or not there is an issue that they need to talk to somebody about. Because remember what I said earlier, you rely on subject matter experts. You're exercising your duty of care by going to the subject matter expert who will help you sort out whether or not you have a conflict.
If I can just add one other thing also, because like Nellie, don't ever think, well, this is more personal to me. I can't go to Nellie because, this is my issue, not my issue as a trustee. Let us figure that out. Come to us first. And if there's a conflict where we have to tell you, I'm afraid you're going to have to, get outside counsel or your own personal counsel, given the particular facts of your situation, let us tell you. But don't ever hesitate that, well, I'm just, not that we think you're busy, but I don't think this is appropriate for you. We're here to help.
And I think that's a great springboard into another question that really nicely dovetails, which is, what are some of the areas or situations in which you may have seen a board member or the president or the regents or those under their authority, right, be confused or kind of inadvertently wander into unsure territory about what capacity that decision maker is acting. So can you kind of give some examples of where those personal professional lines might become blurred for your individual clients?
Sure, let me go ahead and.
Yeah.
Hypothetically, right?
Hypothetically,
Yeah.
of course.
Hypothetically.
Everything is here is hypothetical.
Absolutely. So I'm going to give you a cultural reference that's going to date me, and that's okay. Um, there was a advertisement years ago, right? And it was for an investment company, and it was called E.F. Hutton. And the ad was, when E.F. Hutton talks, people listen. Well, I've turned that into, when a trustee or regent talks, everybody listens. So when a friend of you, if you have a friend that calls and says, hey, I have this issue, my daughter is at the school, and I know you are a regent at that school, and she's having a little issue. Could you look into this matter for me? What do you think? No, of course not. Of course you can't do that. Why? Because you aren't being asked to act as a high-level policymaker. All of a sudden, you're being asked to act as maybe a manager, and that's not your role, right? So you have to be very mindful and careful when your friends come or acquaintances and say, I know you sit on this board. I wonder if you could look into this for us. That's not the role of a trustee or a regent. And that's, for me, oftentimes in my hypothetical situations, I am asked, someone has asked me to look into this. Is it okay if I just pick up the phone and call the coach and ask him this? And oftentimes I say, no, it is not. It is not okay, because that's not your role. And then we get into the specifics of all that. But for me, I would tell you, be mindful of how it is you are being asked to act. Are you being asked to act as a policymaker or a manager? If it's the manager, I'd suggest you step away from that or call your general counsel and talk to them.
I really love your analogy based on the old advertisement because it's very, very true. I cannot stress enough how accurate it is that when a board member or a trustee speaks, the impact it has on those around to kind of understand that as that's my direction. You might be speaking and asking a question, and it might often be received as I received direction to go do X, Y, or Z thing. And that's why it's so risky to step into the role of manager, even just to ask a question. You might not think you're directing something. And so I love the way you frame that because I think that is 100% spot on. What I would add to that, and this may be less obvious, is you're going to be in situations where you don't feel like you have your board member or trustee hat on. You might be at a social event. You might be at a sporting event. You might be at church, leaving on Sunday afterwards to walk the car or go to lunch with friends from that congregation. And at the end of the day, you just never know when somebody might have a great idea that they say, hey, I feel like the board or they should consider this, and I heard about this thing, or I'm working on this thing. And that kind of feels a little muddy. It feels like, well, I'm a policymaker. Like maybe I should be putting forward this idea for the group to consider. What I would caution you and recommend you do, instead of just kind of putting yourself in this ad hoc position to be acting as a solo person and receive those kinds of things, is to think about what's my plan for when that happens, because it's going to happen, right? So think through, what is my kind of canned response that I'm going to say that can come off polite, not dismissive, but still protect you. And maybe that response is, "Oh, that's really interesting. I got a person that I work with um, who receives all. Anytime I hear a great idea, I ask them to receive that, and then you can kind of say, and here's that person's contact information. If you want to share it, you can do that, and then that way you can let that person know, hey, I got this weird inquiry. I don't want to get out of line or be perceived to be pushing it one way or the other. And typically I would say, like, a safe person to designate would be like legal counsel or somebody who serves in an administrative capacity to your board that can just receive that, and then instead of kind of trying to figure out how to navigate that on your own, people as a group, whether that's through executive session or something else, can kind of figure out, what am I supposed to do with this? And maybe the answer is, thanks for that. And that's kind of the only response they get. But just be prepared for that to happen and kind of think through how you want to handle that so that you're not caught off guard, because that's the time when our desire to be polite kind of kicks in, and then you might overcommit or say you're going to do something or indicate some sort of approval for whatever that is in a way that you really don't mean or want to.
Yeah, I just have a couple of additional points. I love the idea. I mean, it goes back to the game planning, thinking ahead, getting ready, and preparing yourself for when the situation is going to come up, because it's already come up for most of you, and it will continue to come up. That's just the way it is. Just a couple of thoughts. Again, I mean, if there's one thing I've learned about regents and trustees, is that you guys are do-gooders, and you want to do good for your community, and so this is probably not the only thing that you're involved in. And so there are times when you're, whatever other community effort you're involved in is going to require you to speak publicly or to be out in public in connection with that other capacity. And all I can say is just be careful of, with the hat that you're wearing when you're doing it. It's okay to have different hats. It's okay to have different hats. Just make sure that you're wearing the correct one when you're not wearing your community college trustee hat. Now, the other thing, though, is that, and this is what I wanted to bring up, is that when you're out speaking, if you're doing it in the capacity as a community college trustee, be careful that you're not saying things that appear to be speaking on behalf of the board when you don't have that. If you haven't all come to terms as a board on how you're going to do the public messaging on a particular matter, don't go out ahead of your skis and talk about it. Now, I know that, there was an interesting case out of the Houston Community College. If anybody here is from HCC, you had it, yeah. So you were up in front, yeah, you were in front of the Supreme Court earlier this year. And so you do have free speech rights. I'm going to be very clear about that. And hopefully we'll have a few minutes to talk about free speech. As a trustee or regent, you do hold free speech rights. However, being part of a team, being part of this board, you come on it with this compact where you agree that you're going to each, obligate yourself to comply with the ethical rules that you have. Now, does that mean you're not going to have disagreements? Absolutely not. You can have disagreements all day long and play them out in the context of your meeting where you're confronting each other, one-on-one. It's a tricky deal. I mean, you can go out and say things that you want to say, but if you stray from your ethical, rules, and you appear to be speaking on behalf of the board, or you're saying something that wasn't authorized, then you might be censured. And the Supreme Court of the United States says you're all subject to censure because you continue to serve on the board, but it means that the rest of your board members have expressed some disapproval with what you said. So just be careful with that as well.
Thank you so much. And we have, I think, just a few minutes left, so I did want to get to kind of fast forward to one of the hot button topics on the campuses today. And so give you all, each of the panelists, a little bit of time to discuss how the issue of freedom of speech and academic freedom have been affecting their campuses, and what legal questions have come from those experiences. So Amanda, do you want to start and go that way?
Yeah, I'll jump in, and
Yeah.
I'll say at the outset, I'm so sad there's only 5 minutes left, because
I
this
know.
is a topic I could spend a lot of time talking about. Some of you may be familiar that the University of Texas had a Fifth Circuit opinion that came out last year, right before the holidays, that was disfavorable, and it was on the speech front. I'm going to give you a brief synopsis and then kind of tell you how that impacted our campus. We used to have a group called the Campus Climate Response Team, which was a group that carried what the Fifth Circuit basically said in a nutshell is higher ed, we don't like, UT Austin, we don't like the way you guys have implemented this. We feel like it chills free speech. You're calling people in to talk to administrators when they're engaging in protected speech, and that's not okay. And a lot of the opinion was, there's a lot of hyperbole in there, that if you took a moment to read it, you might find a little bit shocking that we got such a smackdown for something that was, I felt like, came from such a good place. And the court, the Fifth Circuit was like, I'm not buying that. I don't like it. And things that they latched onto included things like our process for intaking used words like complainant and respondent, which if you're familiar with the Title IX context, you know has to do with somebody being accused of doing something wrong that's a legal, possibly criminal violation, or at least a policy violation, and then the person who was subjected to the bad behavior. And in the speech context, the court was like, that's not okay. The other thing they didn't like is the idea of the grown-up coming to the room, because if you're the person who did something that was protected speech, it's kind of uncomfortable to have a grown-up on your campus who has a title and authority call you in to talk about how what you did made somebody feel. And so basically the result of that was we dissolved that group, and we reassessed how we take the temperature of what the climate is on campus. And we make sure we do it in a way that doesn't suggest somebody's doing something bad or wrong, and it's more about information gathering and sharing. And the intake of that information is conducted in a way that's neutral. It also provides opportunities for people to share positive things. But the reverberations of that case went much farther than just that group. It's impacted how we look at things like training for faculty and how they deal with disruptions in the classroom. Because imagine, let's say you have a student who's a veteran, and on their laptop they have a quote about war or guns or something like that. And in this day and age, those kinds of things can make others uncomfortable. Imagine how, if a student made a complaint about that, how that could have ripples, and before you know it, that person's in having some sort of emergency assessment to figure out if they are threatening the school or to do something. And so we've really taken a fine-tooth comb to look at how we have any kind of instance where there might be protected speech happening, how we're going to train those that interact. So they're doing so in a way to protect First Amendment rights, but that they're still engaging in a way that's positive and furthering the mission of the school. So it's complicated, and I'm looking at time and thinking that's all I'll say, but I highly commend to you the Speech First case that was against UT Austin to read, to just get a flavor of what our Fifth Circuit Court thinks about higher ed generally, because if you've not read that, it might be shocking to you.
That's great. Nellie, do you want to weigh in, and then we'll come back to Augie? Yeah.
Clearly, we have 2 minutes, so I promise I'll give you a minute, Augie. The one thing I would ask that you do, go back and ask your general counsel. Tell them, I would like you to give us a briefing, a high-level briefing on freedom of speech and academic freedom. You need to have some basic knowledge of the two principles, the two concepts. Books and books and books are written about this. We can't cover it in 5 minutes. So you need to have some basic understanding of it, because it's not as simple as it may look. And for me, what I have found is we generally have come across freedom of speech issues and academic issues in an employment law context. A professor says something in a class, it gets on social media, and then there's a whirlwind of activity out there, and regents and trustees are then called upon to do something. What's going to happen? What do you do? And you as trustees and regents need to kind of take a moment and find out, what is it here that's happened? Is it an item that falls under protected speech, free speech? Is it an item that falls under academic freedom? You have to look at the context of how these issues come up. Context is always so important on both of these, but that's why we can't really get into the granular of either of these concepts. I commend you to your general counsels to ask for this high-level briefing.
And I'm just going to second Nellie's call to action, the action item that she's asking you to take away. So this year has been a cool year for me. I mean, I've actually had the opportunity to present at a couple of conferences, both nationally and locally, to trustees and administrators on free speech. So Healy v. James is the Supreme Court case that was decided 50 years ago. This is the 50th anniversary of Healy v. James. It came out of a small Connecticut college where a student wanted to get official recognition of a local chapter of the SDS. Yeah, the timing of this is the late 60s. There was a huge anti-war movement, civil rights movement. There were protests on campus. The president's offices were under siege. Demonstrations on campus. Sound familiar? Yeah, we're going through it again. But I'll just say that out of that, I mean, the president had to weigh and balance what many institutions have to weigh and balance today. Okay, what's the safety risk? What's it going to take to allow this to come on? Understanding that free speech means free speech. You've got to let them on. I mean, whatever restrictions that you're going to put on have to be reasonable. President in that case said, no, I'm not going to allow this group to be established on campus. Went all the way to the U.S. Supreme Court. They reversed that and said, no, that was wrong. There's a freedom of association and a freedom of speech right. University, college campuses are marketplaces of ideas, right? That's where that comes from. And I always like to whenever I gave a speech in front of a mixed crowd that was, 4-year institutions as well as 2-year institutions, I like to brag about community colleges and say that free speech is every much as important value to be talking about at the community college level. Let me just leave you with 2 things. First of all, lots of polling that's been done in the last 6-7 years of students on free speech has revealed something really kind of interesting. Students today don't value free speech as much as they do other values, like inclusion, like diversity, like anti-bullying. Okay, can you help them? I mean, that's what we've trained, our youth to be, right? To be inclusive. And their position is, why should I allow somebody that's saying something that's totally intolerant in my space? So those are the issues you've got to work out at your campuses. You start with your general counsel, you go to your board, and then you go to your entire community, including your students. Last thing I'll say, the last shameless plug for my college. So I had a conversation with some faculty members over the summer, and I told them about these presentations I was doing, and they took the initiative back in October during Free Speech Week, and actually held, I don't know if it's the first ever, but it's the first in a long time, Free Speech Day at Del Mar College. And they had panels of press, the media, they had local reporters, they had panels of faculty members talking about academic freedom. They invited me to do a little bit of a talk on the legalities involved in free speech on campus, but it was a first step. And it was a great way to interact with the students and to get engaged that way. So free speech is I could go on and on, like Nellie and Amanda, about free speech. It is a core value. I believe it goes to the heart of what we do at our institutions, and I think we ought to all put some mind to it. Thanks.
Thank you. We could obviously talk to you all for hours, but we thank you so much for your time and attention today, and we hope that the service of this panel has helped you do a better job in your service to your institutions. And they'll stay, if you have questions, they'll be here for a minute.